Hello, everybody. Did you know that USCIS is thinking about changing certain forms? So if there's someone you know who's applying for the work authorization, the I-45 application, or asylum, uh, listen to this. I'm immigration attorney Carly. In the last few months, USCIS has rewritten a few forms. The I-589, which is the asylum application, the I-765, which is a work permit application, the I-45, which is a green card application, okay? So new additions, new questions, new fees. In one case, a proposed rule that could change how long people wait for work permit by years, not months. So I'm going to walk you through exactly what's going to change, what's still just proposed, and what the hard deadlines are. So nothing you file gets rejected on technicality. So let's talk about a few of these things, and let me take you through one by one, okay? All right, so first, let's talk about the I-589, which is the asylum application. There is a proposed rule that would almost double the wait time for a work permit. Second, Form I-765, Employment Authorization Form, or the EAD, including a hard cutoff date in September with 0 grace period. And the I-485, which is the adjustment of status, included a major rewrite of the public charge section and a new policy amendment that gives officers more discretion to deny. Okay, so at the end of this, I'll give you the 3 things that every applicant should do right now, regardless of which form you're filing. And one disclaimer before we start, this video is for general purposes, general information. Legal advice and immigration rules, especially right now, are changing fast. So make sure you talk to an immigration attorney before your specific case is filed. Okay, so now let's talk about the I-589 application for asylum and withholding of removal. Okay, there are 2 layers of change. One, which already happened, and what's the proposed rule that could happen next. So since the start of this year, asylum applicants have been filing under an edition that changed some of the basic language in the form, including certain technology. For example, instead of saying citizen, they say alien, and narrowing the gender question to make it only male or female. All right. So USCIS introduced new fees tied to asylum filings for the first time, with an additional fee adjustment that took effect in January of this year. If you remember, if you're filing, don't guess at the fee. Check the fee schedule on the USCIS website same day you file, because these numbers are constantly changing and constantly moving. So over the summer, DHS did a little correction, fixing the drafting error, and reinstated a 30-day processing time frame for initial work permit applications. Okay, so it also clarifies something important. The I-589 filing fee is non-refundable, even if your application ends up rejected. And it applies whether your case is later denied or simply rejected on something technical. And that's retroactive to the end of May 2026, so it's already in effect. Now, here's something I want you to listen to, and this is something important. There's one that is still a proposal. It's not final. In February 2026, DHS proposed a rule called Employment Authorization Reform for asylum applicants. If finalized as written, it would change how and whether asylum applicants get a work permit while their case is pending. Right now, in general, an asylum applicant can apply for a work permit 180 days after filing. The proposed rule would push that to 365 days, a full year of waiting. So that's a full year rather than 6 months. And it would stretch the initial, they take the process, that work permit from 30 days to 180 days. So this is important. I want you to listen to this. Now, the part that's raising the most alarm in the immigration with immigration attorneys, the rule includes a mechanism that could pause acceptance of work permit applications entirely whenever the average asylum processing time exceeded 180 days over that period. So given current backlogs, some people are estimating that that pause could last anywhere from a decade. So it doesn't really make sense. So that's not a guarantee, but it tells you the scale of what's being proposed. And we're hoping that things won't get out of hand, okay? And the rule also add a new disqualifying category. For example, entering without inspection after the rule takes effect, with narrow exceptions for filing asylum application for more than a year after arrival. So as of this recording, this is just a proposal. Don't get scared. It hasn't been finalized. I just want you to be aware of what immigration is thinking about. Okay. Now, we have also the I-765 application, and that's the application for work authorization. That one as a hard deadline, to regardless of why you're filing. And the hard deadline is this: USCIS is requiring a new form, I-765, which will start in September of this year, September 15th. There's no grace period. File in the old edition, or after that date, it will get rejected outright, and it will not be returned for correction. So if you're helping someone or you're filing the I-765, get the new edition and file early. And why the new edition? Because it's tied to a big shift. DHS has eliminated for F1 students duration of status, and also for the J1 students, and also for the visa foreign media representatives. So this is important that you remember on the application that is going to change. So the rule shortens the post-completion period for F1 students from 60 to 30 days. And if someone needs more time beyond that period, they have to affirmatively file Form I-539 for the extension of stay before that period runs out. So F1 students, be aware that I-765 is to change. And remember that you have to file your applications ahead of time. All right? So this is important. And this builds on changes in effect from last year. Automatic extensions for people renewing certain EADs ended in October 30, 2025. And that means renewal applicants can no longer keep working automatically past the card's expiration date. They have to refile. Receipt notices no longer authorize people to work on their own. You need a physical EAD card in hand in order to work. And for people with pending adjustment of status applications or refugees, asylees, the maximum period for the new card from 5 years went down to 18 months, and effective December 2025. That means more people filing renewals more often, which is exactly why no automatic extension change above matters a lot. So remember now, September 15, 2026, the new I-765 edition is mandatory, no grace period. Bottom line for this form, the paperwork window is tighter, the validity period is shorter, and the safety net of automatic extensions and receipt notice authorization is gone. So you have to do everything with time. All right, now for the I-485, two things is going to change, and USCIS is really going to be strict on this. The new edition will come effective September 18, 2026. So again, there's no overlap and no grace period. Old edition of the form now if you're filing, but after that date, you need to file a new edition of the form. The old edition will not be accepted regardless of what was prepared. If you're preparing the case right now, decide upfront whether you're filing before the 18th on the current edition or after that. So really try not to get caught in between. All right, so what are the changes going to be on the I-485 application for permanent residence? It's going to be Part 9, which is the public charge section. And that's very important. Remember that USCIS came out with new public charge rules. And what used to be a question about cash assistance and institutional care is no single question. Have you ever received any means public benefit? Okay. Two old disclosure tables were merged into one table. And importantly, it now includes a free text reason file, so applicants can explain the context behind any benefit they received. USCIS also removed the column that used to ask whether a benefit was received while the applicant was exempt from the public charge. Now you just report the dollar amount when applicable. The household size also changed. Instead of number, applicants now describe their family status in their own words. And USCIS stripped out several pages of instructional guidance, what used to explain which programs counted for public charge and which didn't. So pointed applicants to online resources instead. And because of this, expect the question numbers throughout the rest of the form to have shifted. Don't rely on old checklists that reference question numbers from the prior edition. So this builds on the prior edition update. The questions are deeper on the entry, exit history, the income of the person, the assets, the education, the change sex field to biological sex, limited to male and female, And then the I-693, which is a medical exam, that's now being that's now very important. Okay, so you have to be very careful now when you fill out the I-485. Don't take it for granted. Okay, and remember now, in May 2026, USCIS issued a guidance directing officers to apply more discretionary standards to the adjustment of status applications. And now it directs the officers to weigh factors like whether the applicant could instead complete processing through the U.S. consulate abroad, and whether there's evidence of improper intent when they use a temporary visa to come to the United States. So they're going to evaluate all of that. All right. So, of course, just to remind you that the TNU visa holders and victims of human violence, victims of these are humanitarian type cases, and the USCIS memo doesn't create a brand new legal standard for those if they're applying for adjustment of status. So really now the officers have more room to scrutinize a case, more room to push someone towards consular processing. That means instead of doing their residence here, they would have to do it abroad. And if there's any complexity in someone's immigration history, there's a conversation to have with an attorney before filing, not after. So that's so important. So across all three forms, the addition change on hard deadlines, zero grace periods, fees and processing timelines are going to be kind of narrow. And the asylum and green card context, USCIS is layering in more discretion, more scrutiny, not less. If you're going to download the form from the USCIS website, make sure you have the right form. Check the edition date. It's at the bottom. It's printed at the bottom, and it tells you the edition date. And build a buffer before you get close to the cutoff date. September 15th for the I-765, September 18th for the I-485. And those forms can be filed before those dates on the current edition, but don't wait until the last week, because then if it arrives late, what's going to happen? Then if your situation involves overstays, a complicated entry history, prior denials, or you're watching that proposed Asylum EAD rule, talk to an immigration attorney before you do anything, okay? This is so important. All right, so remember now, changes to the I-589 forms, the I-765, and the I-485, and these are changes coming up this year. All right, so we have, I'm going to take some questions for those of you who have questions. I know that there are a lot of questions that people have right now regarding this forms and many other forms. Okay, so let's see what questions we have here on Instagram. If you have any questions and you want us to answer the questions, YouTube, if you have any questions today, you want us to talk about what's going on with, yesterday we talked about the fact that with the F1 visas, that there is already a lawsuit by a group of universities and educational organizations that are going after DHS. Why? Because they have changed the DS, duration of stay status for students, and now there's a limit on how long you can stay in the United States. 4 years for undergrad, for the PhD student, less time. So if your course or your curriculum or whatever you're studying goes over the time limit or the time that you thought, 4 years, 5 years, USCIS is saying, no, you have to ask for an extension or you have to leave the country and come back. So that lawsuit is to prevent that, to allow international students to have a DS, duration of stay. That's a lawsuit that's pending. These proposals, these changes with the I-485, changes with the I-765, the I-589, more than likely they're going to go through in September, like we talked about, September 15th, September 18th. These changes are already changes that immigration is thinking about, especially with the I-485. Those changes are definitely going to go through. So if you're going to apply for residence, you really have to think about all these changes. Now, something that people always ask, they'll say things like, I personally did not take any benefits, or I didn't have any, I didn't receive aid from the government, but my children did. So you really need to explain it on the form, because immigration is not going to, immigration could say that you're lying to them if you don't disclose all of that information to them. If you have children who are U.S. citizens, if you have children who have been sick, or children who are on disability, and they accepted aid from the government, you have to disclose all of that information on the form, because sometimes people think, no, I don't have to tell people, I don't have to disclose that information on the form. It's very important that you do. And then there are people who will say, you know, we have these cases where I am married, but I'm going to get a separation from my husband so that I can receive help from the government. You know, it's very important that you don't lie to the government. If you're in a situation, if you're married, you're married. Don't get a separation just to get public benefits, and definitely do not lie. You are separated if you're married, because immigration is not. You're gonna get denied. You're gonna get denied in a situation like that. So please don't do something like that. And then I have cases where people say, well, you know what? The form asked me if I was arrested, but I'm now 40 years old. And when I was 16 years old, I had a problem with the law, but that was a long time ago when I was a minor. That doesn't count, right? No. Immigration knows everything. Immigration, you know, when you file your application, your I-485 application, your application for residence, remember you do fingerprints. So if you had an arrest when you were 16 years old, 15 years old, you need to disclose it. Immigration, you can't lie in the application, because the application is asking you to be truthful. At the end of the application, you signed it and you said, I need to, I swear that all the information on this application is the truth. So please tell them everything that happened. If you had an arrest when you were 16 years old and you're now 40, you need to put that on an application. And this happens a lot, especially with people who are applying for the citizenship. They lie on the application, or they forgot. Oh, you know, it happened when I was young and I didn't know what I was doing. No, you need to tell immigration every single thing, every single arrest you have ever had in your life. You need to put that on the application. That's super, super important. Don't leave anything out, because if you do leave something out, you're going to get in trouble. Immigration is going to say that you're lying. Okay, and the other thing too that I want to remind you guys, remember that USCIS doesn't take money orders anymore. You have to fill out a form. You need to just put your credit card information on the form. I've seen a lot of situations where people forget the number because it's a long number, right? 16 digits. People forget sometimes. They don't check the numbers, and then immigration sends the application back. Says, oh, we can't get the fee because the number of your credit card is incorrect. Now, remember now the new rule. The new rule is that immigration is not going to do RFEs anymore, or very few RFEs. So if your credit card information is incorrect, or bank account information is incorrect when you send an application, you know what they're going to do? They're going to deny the form. So I don't want you to get into that situation. It's better for you to spend some time, check information with your attorney. Go over the form with your attorneys. Just because an attorney is filling out your form, that doesn't mean you shouldn't sit down and go over it yourself. A lot of times people say, well, the attorney is filling it out, I don't have to review it. Review it. Even though an attorney is doing your form, review it. Review it with the attorney. Review it with the paralegal in the attorney's office. Make sure everything is correct before you submit to USCIS. This is all very important. Okay, so I know it's a Friday evening, and a lot of you are probably tired. It's been a long week. We're going to keep on giving you updates here. We're going to help you understand the immigration process. So we want to say to you, be calm, be happy, panic, because when you panic, you can't think, right? So be calm and talk things over with your family. You can talk things over with your family. Talk things over with a friend. And especially talk things over with your attorney. Make sure that the application is going smoothly. Make sure that you are happy with the application before you sign it. Don't just sign things. Make sure you review it before you sign it. And have a great weekend. God bless you all. And we will talk next week.